now free to leave. We now turn to the second case on our docket, D.M. versus M.D.
May it please the court. Good morning, Your Honors. My name is Mike Brownlee, and I'm here on behalf...
Could you speak up a little bit?
Oh, I'm sorry. My name is Mike Brownlee, and I'm here on behalf of the appellant, D.M., who I'll refer to as mother during this oral argument. And I'd like to reserve 5 minutes for rebuttal, please. Your Honors, the issue in this case is whether Florida courts are required to apply the plain meaning of Florida statutes. I think the answer to that question is a very easy yes, but here we are. And I think the fact that this case has progressed as far as it has, and we're all the way up here, underscores the need for this court to send a clear message to the courts in this state that when the legislature says something, it means it. And I think if this court is not inclined to do that, the legislature may want to heed the advice of Justice Scalia in one of his dissents when he said perhaps the legislature should just start ending every statutory provision with something to the effect of, this time we really mean it.
Counsel, may I ask you a question regarding the provision, the statutory provision at issue? The trial court, when it entered the order denying termination of parental rights cited to Florida Statute 39806, the petition at issue was under 63-089-4, correct?
Correct.
For purposes of the argument, is it your position that under 68-089-5, which talks about dismissal of a petition, so theoretically it shouldn't have been a denial, it should have been a dismissal of the petition, but is it your position that it's reversible error, per se reversible error, because the order did not include written findings in support of the petition, just denying the petition?
Absolutely.
Now, but your position is that it's reversible error?
Correct.
Per se?
Mm-hmm.
So you want this court to write a bright line, to write an opinion that says it's a bright line rule. If the statute requires written findings, it has to be per se reversible error?
I do. I think that's what's appropriate.
Let me ask you this. Would that apply in a case where the parent in question had been sentenced to life in prison?
Yes.
Why would that make sense? To have a per se error rule in circumstances like that, where that seems to be there's only one conclusion that could be reached.
Sure. Under
that particular statutory provision.
I think it's because, well, first of all, there would have to be a best interest finding, but assuming that was all done properly, I think it's because the legislature very rarely requires written findings in an order or a final judgment. And I think that means something special, and the legislature says what it means, and I think the courts are duty-bound to apply it.
Well, the legislature also has a statute about harmless error.
Yep.
Which is a broad statute. Wouldn't you agree?
I agree.
Let me ask you this. Let's go back to kind of a threshold question here about jurisdiction. Now, I want to ask you a specific question about three cases.
Okay.
Schaffner, Farley, and Callwood, if I'm reading my handwriting correctly here.
Okay.
In any of those cases, is there any mention of harmless error analysis?
I think the best one would be Callwood, and they don't use the phrase harmless error, but there's a clear indication that they're unwilling to go look at whether or not the issue in that case was equitable distribution. And there was a lack of written findings about, the findings that need to be made under that statute.
But there is no mention of harmless error. There's no suggestion that the court considered, there's no express suggestion that the court considered whether harmless error analysis was applicable or not.
I disagree, Your Honor. In that case, they said there's a failure to make the written factual findings, and then there's a line that says whether or not the equitable distribution was equal or unequal, the failure to make those written findings is reversible error. And I believe
but that's a per se
reversible
rule.
error. Does it ever use the term per se reversible?
No, but
So no mention of harmless error and no mention of the category of per se reversible, right?
well, I think if the court, if equitable distribution is what's at issue in the case, and the court is saying we're unwilling to even assess whether or not the distribution was equal or unequal, I believe.
Well, there are all kinds of
that's
reasons the
that's
court
harmless error.
might decide that. They might just decide they want to send it back. Our jurisdictions depends on express and direct conflict, and I am struggling to find that. I don't disagree that in this case there's a problem with the way this was handled, and I struggle to see how the error here could be harmless. But that's really an academic question for me if we don't have jurisdiction, and I'm just struggling to see why we have jurisdiction when none of these conflict cases say anything about harmless error or anything about per se reversal.
Well, some of them do. First, let me address those ones. I see this as a pure issue of law. It is a procedural question. So in the same sense, let's say the issue before the court was the appropriate standard on summary judgment. And one district court of appeal had said, self-serving affidavits cannot be used to defeat summary judgment, and another district court said they can. Well, we wouldn't care what the facts were in each of those cases. It wouldn't matter if the summary judgment dispute was a homeowners association issue in one case and a PI case in the other one. We're talking about a pure legal issue that's procedural. If those factual findings aren't made, what happens?
But we know, but on the question of harmless error, we know that sometimes courts simply don't consider whether an error is harmless or not.
Well, I believe that would be in contravention of the harmless error statute. I think.
Well, but we can know for a fact that it's not brought up and it's not mentioned, can't we?
I think if it's not brought up or mentioned, because a court is obligated to consider harmless error in every case and is not permitted to reverse unless there's harmful error, I think you have to assume that they've made a finding that it's not harmless. But I can give you an easier path up the mountain. The JS, Department of Children and Families against JS, that one is, I think, is as close as we can get factually. It's a termination of parental rights case. It very clearly says the failure to make factual findings in termination of parental rights proceedings constitutes reversible error.
But counsel, I thought your initial position was that the harmless error statute didn't apply here, and that it was per se reversible regardless. And now I thought I just heard you now saying that the court does have the obligation to apply the harmless error statute.
I think a court is, according to the language of the harmless error statute, every court is supposed to only reverse if there's harmful error.
Okay, so then are you not taking the position then that it's per se reversible error?
No, I'm still taking the position that if the legislature is saying that certain factual findings need to be made in writing, that regardless of whether harmless error was explicitly discussed or mentioned, that it has to be, it is presumptively harmful to not make those findings. because the legislature doesn't do it very
So
often.
so the case, sort of so the obvious hypothetical of where the judge orally says, checks every box, which obviously didn't happen here, I mean, far from it. But imagine the case where the judge does everything that the judge is supposed to do substantively, but doesn't reduce it to writing. You would say that that needs to be reversed.
I would.
And what authority does the legislature have to say that a judge has to do something in writing as opposed to just making certain findings to
From a separation of power standpoint,
Yeah, I mean, could the legislature say that it has to be in writing and the judge has to write 3 paragraphs on each element?
I suppose it could. I think that might lead to some infringement, but I haven't considered that, and it doesn't seem. But the legislature does do that, and it, at least to my knowledge, hasn't been challenged. And if the legislature says something in a statute, the courts are duty-bound to follow it. And I know that the result might be absurd in some cases. I can envision, Justice Kennedy that's a good example. But be that as it may, and you see it a lot of times in sentencing cases, where there's a sentencing error that was made, and it won't affect the outcome of the sentence necessarily, but they're still remanded for an order, for entry of an order that complies with the law. And Your Honors, I believe
if the decision of the trial court without any written findings had been to terminate parental rights in the father because, say, Justice Kennedy's example, it was a life sentence, and there was an appeal from that, and there was an oral finding that obviously this is a life sentence, so there's no question that this father will be gone for the entirety of the child's life, not just his minority. So you're suggesting that your client, then the mother in that case, would need to wait for an appeal, a reversal, and a new hearing or written findings because there's no harmless error standard. That's.
Your Honor, I think the proper result in that case would be for the appellate court to maybe even retaining jurisdiction, remand for, a written finding that complies with the oral pronouncement.
I mean, where you started was we should follow the statutes. Why shouldn't we follow the harmless error statute?
Because when the legislature explains very explicitly how a trial court is supposed to exercise its...
Aren't those, when we're talking about an appeal, aren't those statutes related? Aren't we supposed to consider related statutes together? I mean, they required findings, but they also said that we should apply a harmless error standard on appeal. So, I mean...
Yeah, I mean, I understand, but if the legislature is in this very small subset of statutes going out of its way to say we want written findings in the order or in the final judgment, I think that it can't be harmless when you don't have those.
If I can go back to the conflict issue. In JS, the statute in JS, the section 39806, that statute does not require written findings, correct?
Correct, not as far as I know.
So in other words, there's nothing in there that says, like here in this statute, you have to make specific written findings, right?
It just says in all termination of parental rights cases that there has to be written findings.
That's a case law determination. It's not in the statute itself.
Correct.
Okay, so at least with regard to that, there isn't a statutory companion to the specific written findings that the legislature has written in with regard to Chapter 63.
Your Honor, when I get up on rebuttal, if I can look through my notes, I'm not certain that that's the case.
Okay.
I think there might be a provision in a different part of 39 that does make that requirement, but I don't want to say that without being 100%
Okay,
positive.
for everything, certainly it's very common in termination of parental rights cases to have a written findings, but with regard to the findings for incarceration, there's nothing requiring any specific findings, correct?
I don't know if the language that this provision I'm thinking of in 39 speaks broadly enough that it would encompass abandonment or any scenario under the statute. But
Feel free to look at it in rebuttal time.
I will.
With regard to alimony, I know some of the cases you cite are regarding alimony. The alimony statute does not specifically state written findings, does it?
Yeah, I believe it does.
61.08 subsection 2, in determining whether to award alimony or maintenance, the court shall first make a specific factual determination as to whether either party has, and then if the court finds, they need to go through the factors. There's nothing saying a specific written finding, right?
Okay,
Case law has said that,
right,
but it's not in the statute.
right.
How does, assuming I'm right in reading 39-806 and assuming I'm right reading the alimony statute, how do we deal with conflict where, in the one hand, there is a legislative requirement here, but there doesn't seem to be a specific legislative requirement with regard to those other two statutes?
I think you could still have a basis for conflict. If it's, I think the mandate is obviously much stronger if it's a statute, right? That's our concern here. But if the law binding on the court based on common law or statute is that there is this requirement.
But if we're reading different statutes different ways, how does that create a conflict if it's not the same statute?
I take your point. Your Honors, I'd like to also point you, I believe the case is Milo versus Milo, which we cite in our reply brief. And I think that case also has a very specific, there is an explicit harmless error finding, if you will bear with me. Yep, in Milo versus Milo, the Second DCA reversed because the trial court failed to make the statutorily required alimony findings of fact in the final judgment. And the court refused to affirm based on harmless error because the failure to make such findings forces an appellate court to make findings of fact that should have been made by the trial court. And that is 718 Southern 2nd, 343. Which also makes me wonder, Your Honor, about the challenger reading of the alimony statute. It does,
please challenge it. If I'm wrong, tell me.
At least that Milo is saying that there is a statutory requirement.
With regard to 39 or with
No,
regard?
excuse me, but that's alimony.
I read to you the alimony statute. Let me know if I'm reading it differently or if it's changed in some way, but I just read to you exactly from the statute book.
Maybe that's just a misquote from the Second DCA. I don't.
Well, what I wonder, and I guess my question to you is, certainly by case law, we have said there needs to be a findings as to each of the alimony factors, but the statute doesn't seem to have it there. Does that matter for our jurisdictional analysis? That's really what the premise of my question is, and that's what I'm asking you. If we've sort of grafted on different readings of different statutes, how can we find a conflict in reading this statute, or at least the way the first DCA read this statute, or the Fifth DCA read this statute versus?
I think that's fair. I would concede that you probably can. I think it is dependent on it being rooted in statute.
Thank you.
All right, you're now into your rebuttal time. So you may continue. I'll give you an extra minute since we helped you consume some of it.
Thank you, Your Honor.
Good morning. My name is Elizabeth Harris, and I'm here on behalf of the father. And I'd like to start right with the conversation we've been having about whether there is, in fact, conflict jurisdiction here. The statutes, the mother's alleged conflict in what I take as three different areas. The first being the one we've been talking about specifically with respect to the written findings. And I would suggest that there is not conflict jurisdiction here because what the mother's asking us to do is to look at areas that deal with family law and equity. We have all of which cases don't make that per se bright line finding that if you don't have findings of fact, it's automatically reversible error. And what the Fifth District here did was expressly applied a harmless error analysis. And the cases, while they may not use the words harmless error, they do talk about hampered review. They do talk about an inability to understand the rationale of the trial court in making the decisions. So,
but how can in this case, how can the appellate court have properly found or had appellate review when the trial court made no findings of fact? I mean, do you concede that there are no findings of fact in this order?
Well, I concede that the order is not done as perhaps it should have been done. But I would say this.
Well, first of all, it's done under the
Wrong
improper statute.
Correct, absolutely.
And two, it should have been a dismissal, not a denial.
Absolutely.
And the statute is very clear that it says the order must include written findings in support of the dismissal, including findings as to criteria in subsection 4 if rejecting a claim of abandonment. It has no findings of fact. So how can the appellate court even make a harmless error analysis when there are no findings of fact? I mean, are they supposed to be making findings of fact, the appellate court?
Absolutely not. And I agree that there are a great number of problems with the order. I would suggest that what the court did here is when you look at subsection 4B, the statute says the child has been abandoned when. The statutory language is a bit different than in, I guess it would be subsection A. The statute says the child has been abandoned. And what we have the trial court doing here is saying there's no abandonment. I think that what the Fifth District did is then do a review and determine that based on an important component here is the trial court made a finding with respect. The trial court says, I reviewed the evidence and the credibility of the witnesses. I think that directs the Fifth District's review of what it could do.
But the trial court specifically reserved its ruling after concluding the hearing and taking testimony, and she made no findings of fact. So all that the appellate court had was a review of the record and the testimony, but the trial court didn't make any credibility determinations or any findings regarding that.
No, I agree. I agree but the question then becomes, is the Fifth District prohibited from doing a harmless error analysis and determine based on the limited components that were alleged in the petition?
I think the question would be whether you had demonstrated that any error in failing to make findings was harmless. I mean, that's the question the Fifth District would have if it's a harmless error test, correct?
I'm sorry, I couldn't hear all of your question.
So, I mean, if the error, the error was clearly preserved by a motion for rehearing. So in order to prevail on appeal, you would have to demonstrate that the error of failing to make findings, which clearly was an error and the issue was preserved, was harmless. I mean, that would be your burden, correct?
Correct.
Okay, and I'm struggling, I think, to see how you could possibly meet that burden when you can't even tell from what the trial judge says that he applied the right statute. Forget that there were no findings. I mean, that's a different problem that would be hard to overcome. But what is your argument that the appellate court could possibly determine that the trial judge correctly decided this case, that the error was harmless?
Beyond a reasonable doubt.
And I think the statute requires a clear and convincing. I think the statute says by clear and convincing evidence that the best interest of the child would be harmed, and that the incarcerated parent's continuing term of incarceration was for the majority of the
No, we're talking about your burden on appeal to establish harmless error. How could you possibly meet that burden with this order?
Precisely what the Fifth District did was to look at the record and determine based...
But it was a lot of evidence that it would be in the best interest to terminate the parental rights. There was evidence that the father would have no meaningful access, no reasonable possibility of meaning to access to these children during their entire minority because of the probationary term that would prohibit him from possibly even seeing them, but if seeing them, then certainly in a very restricted environment. So, there's plenty of evidence that would have favored a finding in the other manner, and there are no findings. So how can you look at that when you don't know that the trial court even considered the right statutory framework and tell that, okay, that we can tell that the trial judge made a correct decision. Not that there was evidence that could support a decision, but the trial court actually considered the evidence according to the proper standard and made credibility determinations, made findings in his head that would have supported. I mean, how can you possibly show that?
Well, I would disagree respectfully that the evidence was wholly that there would be no contact with the father during his time of probation. I think there was evidence that the father could, with the probation officer's approval, have contact with the children in a variety of situations.
But the father testified he didn't know whether or not the probation officer would allow it, number one, but number two, it was unclear also whether or not that would even be permissible.
I don't recall there being testimony that the father said.
That was litigated in front of the 11th Circuit, and the 11th Circuit found that was an acceptable condition of probation.
And it was. I agree with that, but I don't recall. I would redirect you to the evidence that the father testified that it would not be permissible. My recollection of the father's testimony was that if he were to request it, even if it's under a supervised situation where the father is under supervised visitation, I don't think that amounts to an inability to have contact with the children. Certainly in many, many circumstances, there are parents having supervised visitation with their children and their rights are not being terminated. So I would suggest that even if it were supervised visitation, there is an ongoing contact with the children.
But you do recognize that this is a case that's there kind of in a gray area. Different trial judges could go different ways based on these circumstances. And when we, putting aside the jurisdictional question, when we have no reason to believe that the trial judge even used the correct statutory standard, how could you say, I mean, I just, again, struggling to understand how we could say that's harmless under the standard, the very high standard that the court has adopted for harmless error analysis in civil cases like this.
And I realize you said put aside the jurisdictional question, but the case law tells us that the jurisdictional question has to come first before we come to determination that we would have done it differently.
And as you might well know, from what I've said before, I'm sympathetic on the jurisdictional question, and I voted to not take the case. But putting that aside, for the moment, I'm just on the merits here. I'm still struggling to see by what reasoning we could get to the conclusion that in this particular case, that the error was harmless. I mean, that's like, other than something that's like, well, if we would have done the same thing. Well, but that can't be the standard. That's not what harmless error analysis means.
When the district court says our review is not hampered, I think that leaves us in a difficult position to then say, well, it really is hampered. That's I think the determination which the district court, having had first bite of this, would make the determination that our review is not hampered by this. We are able to take a look at this as within the function of that court to determine that they are able to look at this and say, we don't find this to be harmful error, pardon me. I think that's where we are left with allowing them to make that first initial determination based on the record they had before them that the court could have.
That's a determination of law, correct?
The harmless error?
Yes.
Yes, sir.
So we're in as good a position to make that really as they are.
And I don't disagree with that, but it's the position of determining at this point, in essence, gives the mother a second opportunity to argue that harmless error. And I would question whether we can do that here without going back to this what you asked me not to talk about. And that's sort of the hamster wheel I've been on as I've been preparing for this case, is that I go back always to how do we establish that the law here was either announced different than some other DCA, some other standing law.
Let me ask you about Schaffner, Farley, and Callwood, which I think are the critical cases in terms of jurisdiction. And those are under the dissolution of marriage statute, correct?
Yes, sir.
Those cases, irrespective of what the statute says, expressly say on their face that written findings are required as a matter of law, correct?
Yes, they do.
Okay. And they expressly say on their face that we are reversing because there were no written findings, correct?
Yes, they do.
Okay. And the Fifth District says that there are no written findings. They are required as a matter of law. That says it on the face of the opinion, correct? And yet they are affirming. Isn't that a direct conflict? And it's expressed because it's based on the words that are said in the opinion. Now, the dissolution cases may be wrong, as Justice Luck pointed out, but those, you'd have to look behind the opinion to show that the statute, that written findings are not required.
I think there's more to those cases than just those nuggets.
But that's the potential conflict. If there's a conflict as to that issue, can you, I mean, because I have 3 cases that say written findings are required, and because there are no written findings, it is a reversal. And I have 1 case that says, it says that written findings are required, but we're going to affirm. Those are what the cases expressly say. That's the issue. And
I don't
that
recall,
seems like a direct conflict.
In the cases you mentioned, was Kennedy among the list that you mentioned?
No,
Schaffner, Callwood.
Schaffner, Farley, and Callwood.
And I believe that if we pull that language out, it paints a different, it skews the context, because those cases are saying we aren't able to determine what the court's rationale, why the court did this. We can't determine whether there was in fact an equal distribution.
Right, but how can you do it in this case? This D.M. specifically says the trial court's order does not include written findings as required by the statute. However, the failure to make the required findings can constitute harmless error. How can you, I mean, they're polar opposites, these cases, in terms of the rule of law. Are they not? Where one says if it's required and you don't have it, it's error, and this one says it's harmless error.
I think what one is saying is then it becomes a per se reversible error. And I am not familiar with any case law that says the failure to make those findings under Chapter 61 is per se reversible error. And I think those are the operative words.
When you're talking about conflict, we're talking about the conflict of issues, the same issue of law, right? So does it matter when you're analyzing the conflict of the issue of law of what these findings actually pertain to substantively? Could it be different in different chapters of the Florida statutes according to what subject matter it is? Or does it have to be the same issue of law? Does it need to be arising from the same subject matter?
I think it's got to arrive from the same subject matter,
I'm
because
sorry?
I believe it has to arrive from the same subject matter, because then we're back to the situation that Justice Luck was speaking of taking one statute and the law that pertains to this statute and applying it to another statute. It's dealing with an entirely different context, and we've merged the apples and oranges with a pronouncement dealing with one statute that has specific requirements and specific, for example, in Chapter 61, where equity plays such a role in the decision-making.
Okay, so Farley says failure to include findings of fact is required by law, and it cites a statute, but is reversible error, period. Mm-hmm. I mean, that's what it expressly says. Failure to include findings of fact when required by law is reversible error. That is directly contrary to what the Fifth DCA did and said in this case, isn't it? On the broader issue of when findings of fact are required by law, is it reversible error to not include them?
I think that the operative word is per se, because we know we need to apply a harmless error analysis. And so in the absence of that, I don't know that
But that's not what
conflict
they
jurisdiction
expressly
is.
said. That's not what they expressly said in Farley, is it?
They don't say it's per se reversible. They say it's reversible, yes, sir. I don't know that we have a conflict, however. When the Fifth District said, this is never per se reversible, this is never per se, or they've said it's never reversible, then yes, we would have, but they add that component of its harmless error because that's what statute requires them to do, is to analyze the error under the harmless error statute.
But I think the answer to the Justice's question, though, too, is the same answer that you gave to Justice Polson, which is that the statement that he's reading from is in the context of a different statute, a different substantive area. And so if you take the question of law to a sufficient level of abstraction, then you're kind of undermining what the conflict analysis should be. But let me ask you, though, as far as applying a harmless error, is the reason that we should do that the harmless error statute 59041? Is that the if we're saying, okay, let's apply harmless error, is the reason that we go through that analysis because of the harmless error statute 59041? Is that because I'm reading the statute and it's not obvious that in this context it applies, because it talks about harmless error in cases where there's misdirection of the jury, obviously not the issue here, improper admission or rejection of evidence, not the issue, a matter of pleading, not the issue, and finally you get to or procedure. So before we get to this statute, would we have to first say that this requirement of a written finding is a matter of procedure as that term is used in this statute before we get before we even do the harmless error analysis itself? In order to be asking the harmless error question, would we first have to conclude that this is a matter of procedure that the judge made the mistake on?
I think you do. I think you have to find that the failure to comply with that portion of the statute fits into that language under the statute, under 59.
Under the word procedure?
Yes, sir.
Okay. And is the origin of that being statutory as opposed to a court rule? I mean, is that a problem?
I suppose it might be. And I don't know if this is helpful, but we are applying the harmless error analysis in the failure to make findings in other statutory contexts. And in light of that, I don't see where we're foreclosed from doing that in this statutory context. If in fact, and we are talking about this by comparison with Chapter 61, 61 is allowing that harmless error analysis to be employed with a failure to make findings. We know that from the cases that I've cited in my brief that talk about the harmless error analysis under the failure to make findings in Chapter 61. So if that is happening in that statutory context, I think by analogy we have to take that's where that's coming from, is from the procedure language of Chapter 59. If you don't have any other questions for me, I'll sit down.
Justice Luck?
Yes.
Okay, I think I'm 1.5 for 2 on my research assignments.
Please go ahead.
In Colwood, they're quoting the equitable distribution statute.
So equitable distribution has it. It's a reason why I didn't use equitable distribution. Okay. If you notice, my questions to you were the Chapter 39 and with alimony.
Sorry.
The equitable distribution does say written findings in it.
And that's Colwood.
I understand.
Okay. And Section 39.811, subsection 4, its title is Powers of Disposition, Order of Disposition. This is the 2015 version. And the last...
It says court makes specific findings based on evidence presented.
Based on evidence presented that placement with the remaining parent is likely to be harmful to the child,
Right.
the court may order.
Right. So it makes specific findings. It doesn't say written findings in there, right?
Well, it sounds to me like that's a prerequisite to making the order, but
Okay.
yeah, not as explicit as you'd like.
Not the language, that's not the same language we have here, in other words.
Correct.
Okay.
One other point I'd like to bring to the court's attention. can't lose sight of the fact that the Fifth DCA, the harmless error case that they relied on, was an alimony case. So clearly the Fifth in their decision thought of it as a procedural matter and didn't think it was apples and oranges. Otherwise, they wouldn't have been citing an alimony case. I think that's important. It would be incongruous, at least I think, for the court to decline jurisdiction when the Fifth, that was the very basis for the Fifth's harmless error analysis. It's complicated, but I think that must mean something.
Well, just to go back on the jurisdiction, the problem that I'm having with understanding the jurisdictional argument is that it seems that it requires that in the conflict, at least some of the asserted conflict cases, we equate the identification of an error with the identification of per se error. And those are different categories in the law. And when a court says that this is an error that's reversible, that is not the equivalent of saying that it is a per se reversible error. Wouldn't I be right about that?
I think under that specific construct, yes. But I think if they're saying it is impossible for us to review, we can't give meaningful appellate review because there aren't these findings made and the legislature requires them. I think the roads lead to the same place.
But that could be fact dependent in the particular case.
No, I think it's because the message is that the legislature says you have to consider these certain factors.
Well, it seems like if that's what those courts were saying, the category of per se reversible is a readily available category that they could have deployed, and they did not do it.
Correct. They didn't use the language per se reversible. And this court doesn't have to either. I mean, you can say it's cannot to be harmless error if those findings aren't made. I'm out of time. Thank you, Your Honors. I appreciate it.
We thank you both for your arguments. Ms. Harris, we thank you for your pro bono service in this case. We now move to